Now we will get into a case law, so you will understand about it more well about the variation of class right. Okay, so the first case law is White versus Bristol Aeroplane Company, 1953. So the case is simple. Here, you are the company. Okay, you are the company. I'm an ordinary shareholder, and this Teddy is a preferential shareholder. Okay. So one time you, the company decided of giving bonus issue to whom? Who is entitled to bonus issue? Yes, the ordinary shareholders. You decide of giving bonus issue, and this bonus issue includes both ordinary shares and preference shares. That's what a bonus issue of new ordinary and preference shares to the existing ordinary shareholder. Okay, you're giving me the bonus and I'm only entitled to this bonus issue. So what happens is that the preference shareholders, their heart is broken because they go to the court and they object that on the basis that this is reducing their proportion of class of preference shares. They object it and say that this if the company is giving the ordinary shareholders as bonus issue of new ordinary and preference shares, then the preference shareholders is reducing their proportion of the class of preference shares. So they go to the court, okay, and this is a variation of class right, and we are not consent to it. The Teddy or the preferential shareholder is not consent to such a variation of class right, so they go to court. So what does the court say? The court says that bonus issue is not a variation of class rights because the existing preference shareholders, okay, they already have their number of shares. Is there any change coming into their number of shares? No, right? So the court says bonus issue is not a variation of class rights, therefore they cannot cancel, okay? They cannot come to a court for a cancellation of this class of right because there is no variation coming here. The bonus issue that is only for ordinary shareholders, and by this the number of shareholders that the preference shareholder is holding, is it changing? No. Okay. So that is our first case, okay. Now the second case is the Greenhouse versus Adrian Cinemas Limited, 1950. So the company had two classes of ordinary shares, 50p and 10p shares, with every share carrying one vote. So here, maybe you're not familiar with 50p and 10p. 50p and 10p, they are actually the nominal value of the share. Maybe the market price won't be the same. Maybe the market price may be more than 50p and 10p. So it's just the nominal value, and that does not have anything to do with our case. But I'm just giving you a general information about what is 50p and 10p. So they have two classes, 50p. Okay, I have the 50p shares, and this Teddy is again holding the 10p shares. Just think like that, and every share has one vote. And a resolution was passed. Okay, and it subdivided this 50p into 5. That means 10p each. 5 10p's. Okay, and this will multiply the votes by 5. So they go to the court. The 10p shareholders will go to the court and they will be like, this is not fair to us. This variation of class right. We have no consent to it. And all. So what did the court say? Let's see. The subdivision of shares is not a variation of class rights. Here the court says this subdivision of shares is not a variation of class right because the rights of the original 10p shares, okay, had not been changed, because that 10p holders still have that one vote. Then what is the problem? What is the variation of class rights? So the 10p still had their one vote, just that 50p was subdivided into 10p. That's it. So there is no variation in class rights. So therefore, this case can't be held in the court. So that's about the case law. Alright.